Good morning, Joe.
Hey, good morning.
This is Steve.
Hey, Steve, how are you?
Good.
I'm expecting a decent sized crowd today because we've been circulating a lot of things for signature. So I'm hoping there's some questions that I can get answered. We've got about 290 something forms filled out. We've got about 81 duplicates in that. So we've got 212 unique form completions, which is pretty encouraging.
So how do I find out that mine went through?
So that is gonna be a big part of our conversation. I'm gonna walk through the next my end of this process. I mean, you guys have seen some of that. You sort of seen the middle part of the process. Now it's really the remaining part of it kind of gets a little boring. But I'm going to explain it to the group today, and then I'll send out the recording after we get started. We're a few minutes early, so I'm gonna go ahead and postpone. But the teaser is, Steve, I'm printing two of the three documents that you've submitted. I'm putting them in FedEx envelopes, and I'm overnighting them to the agencies, and that starts a 6-month clock. For the day they receive them starts a 6-month clock. And I'm sending FedEx because I want to have that
signature
on the other end. Yep. It's, I sent a sample of about 8 to 12 last Tuesday, and they got there Wednesday, and I was able to track that. So what I'm going to do will be a very systematic, so I don't miss anybody. I'm going to use the form fills as sort of because I can export a spreadsheet from the forms that you guys have been completing, and that will allow me to make sure that I don't inadvertently miss anybody.
Okay.
What's that?
Well, if that's the boring part, did you come up with any jokes to make it better?
Oh yeah. This I'll try to think of something. It's really there's probably two big offenders in this group that we're working with now. The biggest obviously is the biggest is VOA, and the second biggest, which is a close second, is Social Security. They're the two big offenders who historically have a long history of checkered history of using the contracting system, which is their big fault, right? They just used the procurement system in a way that it was never intended, and that is what's created this headache for the agency, and the problem, the underpayment for you guys. So,
all right.
And the nice thing, I'm able to use, I've created a really tight silo within my AI software that I'm using. So it took weeks really to build it up. I had to go out and collect all of the misclassification case law in the world, all the statutes from every state, surveys from all 50 states, because the state-based claims turn on state law. So, and there's a few, unfortunately weak states in that mix. Louisiana and Mississippi being some of the more obvious. There are still some common law claims that we're able to raise in those states, but there are some really thorny states. I mean, like Virginia, Colorado is, by the way, amongst those thornier states where the employer is held to account, and the damages picture becomes much more interesting, even more interesting than under the FLSA is interesting enough because you're talking about overtime and minimum wage. But in the state-based schemes, you get that at a minimum, and you also end up with what I call a comparator syndrome, a comparator situation. I got Miss Beasley coming in. We got a good group coming in. I'm going to hold off and then I'm going to start from scratch, Steve, just so you know when we get in. But thank you for that lead question. Let's see. That's good. We got lots of folks coming in. Give everybody my normal few minutes because I tried to pick like the perfect time. There aren't too many mountain time folks. There's some central, eastern, hopefully not too many Pacific folks because they would be the ones suffering the most on this call.
Quick question here.
Whoa.
All right, we got some echo going on. That's fine. So if you're on two, usually that means you're on the Zoom call with two sources, and you just have to mute. There it is, Mohammed. You just have to mute one of those sources. If you're on with like a phone and on your computer, you got to make sure to mute one or the other. Otherwise, you'll end up with that unpleasant echo.
Morning, Joe. How you doing?
Good, Daryl. Good. I'm becoming quite the Zoom expert through all of this experiment as well. I've sharpened my AI skills. I was going to explain to the group, and I'm doing this for the benefit of everybody that's on this call, but I'm also going to distribute this group wide. So we're at 10:02. I'm going to give folks. I'm eyeing my attendees tab over here, making sure we've got everybody is unmuted who's joining. So I'll give it about one more minute. And then there's always folks that kind of join us late. But again, the most important thing is this is all being recorded. You also have got a notice to that effect. I'm going to distribute that group wide. That's there. One of the things that informs you guys is like, try to keep the question. We're going to get to a Q&A as we always do. When we get to a Q&A, try to keep your questions fairly general. If you have individual questions, most of you have gotten to a place where you have seen some sort of, hold on one second, we have seen a correspondence from either me or Mrs. Whitcomb, Carrie, my wife. She and I have been working on these cases. We spent a lot of time working on them over the Memorial Day weekend. We crossed the 100 threshold over that weekend. Now we're about to cross over the 200 threshold this weekend. When we break up with you guys, we're going to we've got about 212 unique forms. We have 293 entries, 81 duplicates. Some of you have filled out 2 or 3 entries. And some of those, I mean, like if you're making corrections, that's fantastic. Be very useful if you've got like my email or a text message or something. Just let me know that the entry that you just submitted, if it's a correction, it's a correction, or if it's some of you, like Jason's not on this call, but he worked for 3 different agencies over the time. And if you've worked for multiple agencies, then it's useful to give me 3 different forms, because each agency has to get its own form 95. That's the statutory provision. Making sure that I have everyone is talking permitted. All right, it's 10:04. I'm going to get into this. Again, this is being recorded, so if anybody misses anything or if anybody has a question that I don't address today, well, if I don't address it in the initial part, we're going to open up a Q&A. I'm going to go in the order of the hands that are raised, but let me launch into this by answering a question that Stephen asked before some of you joined, which is, what's next? And it's a great question. So I think everybody on this call, and we have about like I said, I think I just looked this morning, we have 293 form entries. Now that the software I'm using is a product called Cognito, and Cognito gives me an ability to export an Excel spreadsheet of everybody that's entered. So that's a great means for me to not accidentally miss anybody, right? So I exported the spreadsheet this morning. I deduplicated it using your email addresses because that's a really good, you all have used the same email address. Even if you've done multiple entries, you've used the same email address in those multiple entries. And I have 200, as of this morning, I have 212 unique individuals that have done this part of it. So again, for the benefit of catching up those who haven't joined us in the past, this phase that we're in, there's two separate cases, lanes that are happening, right? One big overarching case is what we've called the Lambro or Jordan case that is in the Court of Federal Claims. It's in the only court in the country that it's allowed to be in, which is a Court of Federal Claims. And that is a Fair Labor Standards Act, or FLSA. Most of you have heard that term one place or another. It's the federal statute that demands only two things, which is the minimum wage payment, which is only like $7.50. But in the way that it captures many of you is that it's the tool you use for time for which you weren't paid at all. Time that you worked and you weren't paid at all. That falls under the FLSA minimum wage slot. And for many of you who are at VOA, the one thing that is sort of the common denominator that is missing in many of your forms, but I know about because I've had 5 years of history with this, and a couple of you have mentioned it, which is the on-call time. So a lot of you have said, well, I didn't work any overtime, but I was on call. Well, if you were on call and you weren't paid, that is unpaid. That's unpaid minimum wage. That's time you were required to be available for work, but for which you weren't paid. And there's a little bit of a subjective test that goes with that. So in other words, if you weren't able to, like most of you will say, if you weren't able to travel, some people have volunteered, you weren't able to go out and have drinks with your friends or family because you could be called in on a moment's notice. Some of you have confided in me that you were actually called in on those periods when you were on call. So that is a big uncompensated period for the folks who are on the VOA side. On the Social Security side, and again, I'm just picking on these two agencies because those are the ones that have the most obvious and blatant errors with the government. So the VOA or Social Security side is a lot of the VHRs, and I'm not naming names, but almost every VHR who's on this call was required to go into work, showed up for a hearing, and wasn't paid. They were either paid $5 for, they might have been for a hearing cancellation, of which they had no control of the cancellation. Some of them sat for 45 minutes or an hour. Many of them did work. I mean, there were instances, because I know this job because I was never a VHR, but I was once upon a time, I was an attorney advisor for the Social Security Administration. And you'd be in a hearing for 45 minutes waiting for a claimant to show up and they didn't show, or a VE or an ME to show up that didn't show up. And the judge would sometimes still go on the record, ask the VHR to take, to make a record, but then cancel the hearing. And under the contracts that started in around 2017, 2018, and going forward, that the VHR would get paid $5. The other thing that I want the folks who are at, Carmazzi is a big group of folks that is many of them were under the impression that, and I know this because I ended up representing Carmazzi later against the government. Many of them were under the impression that Carmazzi was holding out on them. Carmazzi had millions of dollars of unpaid invoices in with the agency, and they never got paid. And the government had like all these excuses for not paying them. Most of them turned up. Carmazzi would submit invoices for the hours for the hearings that were worked. The agency would sit on those invoices for a month and then shoot an email back to Carmazzi and say, these invoices are wrong. Wouldn't tell them why they were wrong. Just said, hey, these invoices are incorrect. Resubmit them. And Carmazzi would, the owners who I met would say, hey, what's wrong with them? What do we need to do to get them right? And the government would just fire back and say, that's your problem. You solve it. It's not our job to tell you how to figure out these invoices, but it actually was. So anyway, the point is, I'm going after the Carmazzi is no longer a company. So I'm going after the Social Security Administration now to get them to pay, because our theory of the case is that the government created the contract that was designed to fail. And the people who were ultimately punished for that, who paid the price for that, were the VHRs who did the work. The government derived a benefit of it for it, and they never paid for it. So That's our claim. That's our state-based claim and our FL. That claim, all these claims we're talking about exist in one variety or another in both this Court of Federal Claims case under the FLSA, because of minimum wage and overtime that wasn't paid. And then we're going separately into these state-based claims. So let's say you're a VHR and you live in Texas, or you're a VOA person, you live in Virginia, or you live in Maryland, or you lived in Maryland at the time that you were performing the work. Then you guys have all filled out these forms. What that looks like is I pull these forms. I'm talking with my hands. You can tell I'm Mediterranean, right? So I pull in all these forms to the workflow that I've created, which the workflow is managed by an AI product called Harvey. That I've got, I don't know, 1,200 different cases and statutes that I've piled into that, plus your individual statement, your individual PDF that you guys have completed. That works together to create the sworn statement that many of you have seen. Some of you haven't, but the sworn statement, the Form 95, and the engagement letter. Now, and the engagement letter is pretty standard between everybody, right? And then I print that out. You've seen Carolee and I are working together. Carolee's my wife. She's on my payroll. She's an employee of the firm, so she has all of the obligations to maintain privacy and all the stuff that everyone else does. Anyone else in my firm does. We're putting these into a PDF. We're sending them out through a product called Dropbox for your review and signature. Now, what I want the group to hear is that the most important thing on that document, certainly we want to make sure we don't have any material misstatements, right? But if you say you work 12 hours or average 8 hours or 10 hours of overtime or whatever that is, like that is not a material misrepresentation if you're off by an hour or 2 hours or whatever on that front. One of you caught me and said, over the weekend we fixed it and said, hey, you had me down working for Persian services. I actually work for Russian services. That's not a material misrepresentation and it wouldn't disqualify your case, but I still fixed it, right? Because I want you guys to feel good about the things that you're signing. The other side of that, though, is like I said, there's about 212 of you now, and I expect there's going to be many, many more. So the more accurate we can get, and again, that particular form that I'm talking about didn't say either one. And when I went back and looked at the form, it didn't mention Russian or Persian services. So the AI just made an assumption, which was wrong, right? So the more detail, and again, for those of you who've already filled out a form or multiple forms, I don't want you to fill them out again. It's just easier for me to get communication from you through our software and add to those, but don't fill out a new form because I've already got 81 duplicates in there. Now, the next step, and this is something I'm answering Steve's question again. So the next step is once you guys have signed the documents, and I should be through, I'm guessing I'll be through all 212 unique document. Well, I'll be through the end of this list, I'm guessing, by the end of the week of this coming work week. I have a lighter work week than normal as far as I don't have any depositions or trials going on this week. I had some of that stuff going on in May. I'll get all those forms out this week, is my hope. Fingers crossed. You guys will see them. If you're not, one lady let me know she wasn't getting it through the Dropbox software, so I have another software. I send it through PandaDocs. That enables me to send it through text. Anyway, when I get those signed documents back, I'm printing out just the sworn statement and the Form 95. I'm grouping them by agency. So I'm overnighting them to the agency. So I'll end up with, let's call it 150 VOA. I'll end up with 80 or so Social Security or whatever the number is. So, and I'm overnighting them with a FedEx tracking number, because once they are received, once the agency receives them, that starts a 6-month clock that the agency has to up or down vote the claim. So the most important thing that I didn't finish saying, the most important thing in the document, the thing I want everyone to pay the most attention to is line item 12 in the Form 95, which is the sum certain, the amount of money that we're asking for. Because we can always accept less, but if the government denies these claims, which I'm expecting them to deny the vast majority of these claims, if not all of them, they may just carpet deny all of them. We go to federal court. that would be the next step. We file all these cases in federal court. And again, it'll be in the U.S. District Court for the District of Colorado. It'll be in the U.S. District Court for the District of Maryland, Virginia. They'll be in the states in which the services were performed. California, New Mexico. I've seen Texas. They'll all be filed there. And many, there'll be. My expectation is there'll be multiple filings in every state except a few. I've seen like one case in New Mexico. There's one in Iowa, but there's clusters in California, Colorado, Virginia, Maryland are big ones. Texas has a good number. And then once those claims are filed, then we're in normal litigation. So they will be filed. There's some case law that says in order to file a class action against the United States under the Federal Tort Claims Act, every single one of those cases has to go through this administrative process that we're going through now to give the agency an opportunity. Form 95 is required to be, it's called administrative exhaustion. So we have to go through the process we're going through. I'm trying to position it like it's a class by submitting, hundreds of these things at a time. So that the strategy is the government will either throw up its hands and carte blanche deny everything, or throw up its hands and carte blanche approve everything, which would be very surprising and unlikely. But if they throw up their hands and deny everything, then we can all we'll hold hands together, all go to federal court together, and then it becomes under the what would be analogous to like a mass tort claim. So a mass tort claim, you might think of like you might have read about the asbestos claim in the Johnson & Johnson talcum powder, or another recent example is the weed killer Roundup. Those are mass tort claims. They're not class action claims because everybody's damages are different. In a class action, you typically have everybody's damages are the same. Ford makes a bad tire. The tire costs $100. Nobody's killed it because of the tire, but Ford has to replace all these, pay $100 to replace all these tires. That's a class action because everybody gets essentially the same amount of money. This particular action, the range of damages I've seen so far is like on the low end of $75,000, and on the high end is, I've seen some of these damages are in the millions. So it's going to be, and I told you this guys months ago, but there's going to be individual calculation of damages. And if we get a recovery of minimum wage and overtime in the FLSA claim and Court of Federal Claims, then that will count against the damages that you recover in the state claim, but only for minimum wage and overtime. So in the state-based claims, you've probably seen like the 7.65 in self-employment tax. You've seen comparator. You've seen health benefits. You've seen all of these other things that appear in the state-based claims that we can't chase in the federal and the FLSA claim. So that's why it's a different, I've said before, it's like a different bucket of damages. And hey, Thomas, I'll get you a recording on this. So it's a different bucket of damages, but again, the most important thing to understand is that once you guys sign these documents, I'm going to be printing them out, overnighting them to the government. Each of you will get an individual case number. It'll be like a four to six digit case number assigned to your case. And, the government is responsible for approving or denying each case individually. It can't just blanket say, we're not paying any of these cases. It has to look at, and that's what I'm hoping from, again, because I didn't write the statute, I'm hoping from a strategic standpoint that, this essentially overwhelms the government. I've gotten several from unrelated to this case, but in other cases, I've gotten several emails from the government saying, hey, the DOJ is down. This particular U.S. Attorney's Office is down 64% of its lawyers. Again, all that having nothing to do with me. But the Office of General Counsel in each of these agencies has got a lot of work cut out for them. And the stuff that you guys have like dropped into the collab spaces and sent over in the Clio portals, those are documents that we will supplement our filing with later, because the agency will typically send me a letter and say, hey, I got Steve Justice's claim. Please send me any supporting documents, and we'll be emailing supporting documents on that front and tracking what we send. So that's we're just trying to get. I'm working feverishly to get the 6-month clock started, which is why I'm filing these claims now. So that's kind of where we are now. I'm going to call on. So it looks like I'm going to always do. You do? Tell me if I did a good job on that name or not.
Yes, 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 sir. Thank you. Um, First of all, this was the 12 noon Eastern time meeting, right? When I got 1 minute early, it's already going on. So I don't want to tire you with the same questions.
Oh, I was
But
answering Mr. Justice's question, Steve's question.
yeah,
And it's the one I just finished answering again. So you
okay.
didn't ask anything.
Okay, all right. So
this is also being, by the way, for everybody's benefit notification, this is being recorded. And as soon as the Zoom folks finish giving me the recording, I'm going to distribute it the way I've been distributing everything. But what is your question?
all right. So I just want to make sure I have done everything that you want me to do because every email says fill out this form, and when I click, it looks like the same form that we
It is.
Yeah.
And I think I was clear. If you haven't, I think the way the email reads is if you haven't already completed the form.
All right.
So again, I've got 81 duplicates as a result of sending out these emails, but it's not difficult to filter. So when I complete the form, because again, they're all saved in a. I'll give you guys a quick glimpse of what that looks like, so that you guys see what I'm looking at. So,
yeah, it's a 7-page. That is a 95 form we're talking about, right?
Yeah. So what I'm looking at, so this is what I see, right? And then I download each of these forms, but I have 293 of these forms completed. And there's in that form flow, there's 81 duplicates. and that's, listen, some of them are duplicated because people work for, like, I had one gentleman who worked different times for the same agency. And there was a reason to submit different forms. One gentleman, Jason Lambro, who's like the original case, he worked for 3 different agencies over the 20 plus years, all as independent contractors. So I had 3, because each agency that you work for has to get its own form. So there's no sin in that. If you miss something, this particular software does a lot of things well. What it doesn't allow people to do is revisit the old form and fill out new stuff. But I understand what you're saying, Mr. Wendy, which is the idea that you don't know whether you have. If you're getting an email from me, I understand that these emails that I send out are mass emails.
Yeah,
I'm corresponding with like 375 of you that have shown an interest at one stage or another about this case. But if you've already completed the form, there's no reason to fill it out again. If you have not, and you still want to, then there's every reason to do it.
All right. So again, just to make sure, I got the document, in the Dropbox from Miss Whitcomb a couple of days ago.
Yeah.
So that takes care of the state claim, right? Or the 95.
That's right.
If I sign and send that, so I'm covered with this state claim document you're looking for.
Yeah. Let me look. Yours still shows pending, which means you haven't signed it.
Not yet.
If you sign that, and then if I go back and look, there's 2 separate claims. You have the other claim, which is the FTCA claim, which you signed back in July of 25.
Yes.
So that one is done. So again, and part of what I was explaining is that, like I said, we have 2 claims moving in parallel. The job is not the goal is not to double dip. The goal is to make sure we turn over every rock as it relates to you getting full recovery. And this is one of my small number of superpowers is figuring out how to sue the government. Suing the government, I don't know if I make it look, it's not easy. They have all kinds of immunity. And so you have to figure out exactly what door you're allowed to walk through in order to sue them. So for the Fair Labor Standards Act claim, the minimum wage and overtime, and the reason I had to plead, and this has confused the judge, I had to plead in that case that many of you were misclassified one way or the other. And the judge misunderstood. The judge said, well, this is a misclassification case. No, it's not. It's an overtime and minimum wage case. But I had to argue that most of you folks at VOA, for example, or at Social Security were misclassified, or like in the Social Security case, many of the folks worked for another contractor, and the contractor didn't do anything more than recruit, or they won a contract with the government, and then they put out for bid these different hearings. And I'll pick on Steve, for example. So Steve throws his name in a hat and says, I'll do this hearing. Steve did not have a contract with the government. Steve just had a relationship with the contractor who was doing work. Now, once upon a time, and Steve knows this, but once upon a time, he directly contracted with the government, just like many of the VOA people did. And that is a separate kettle of fish for which I'm still trying to get recovery. But because in those instances, they were on the hook for paying all kinds of self-employment tax and all these other things that they shouldn't have had to pay, and they were working just like W-2s. But the same thing is true with the DOA. So we've got this. The reason I had to convince the court that either the Social Security folks or the VOA folks were misclassified, or that they were working for an employer that had no power over them, was so that to convince the court that the government owed these people overtime and minimum wage. Because the government's first defense is, well, they didn't work for us. They weren't our employees. And my response in writing was, you're right, they weren't, but they should have been. They should have been your employees. So that's, and once we convince the court, which we have, by the way, the government has never, that's the one defense the government has never raised so far. And it's said so on the record. It has no intention of arguing that the economic realities test that makes you folks employees is not satisfied. It's clearly satisfied. You were working on government equipment in a government building. Many of you had CAT cards and codes to get in, and you had, .gov email addresses. Many of you were in every way, shape, and form a government employee, except for the fact that they were sending you a 1099 instead of a W-2, and you weren't getting any benefits, and you weren't getting all this stuff. So anyway, I think I went way past answering your question, but I want to circle back and say that you've got your outstanding engagement. You don't have to do anything more than sign that. Once it's signed, and this is what I want to make sure I revisit. When I'm going to, between now and hopefully the next time we meet in 2 weeks, I will have all of the forms back that I'm going to get, right? And I'm going to pester all of you and everybody who's not on this call, because you guys are all my faithful. You always show up for these meetings. Most of you have completed forms. You're going to. You're like my 12 or 13 apostles. That's a little bit irreverent. I shouldn't have said that. But my point is, you guys are always here. The following, and I've got, like I said, I don't know, well over 150 of these engagements back already. I'm going to get all of those engagements together, get them printed off on a printer, and I'm going to put them in a FedEx envelope, and I'm going to mail them off, and then each one of you are going to get an individual claim number. I'm going to put that individual claim number in Clio, share it with you guys so you can see it, and then and I'm going to calendar a 6-month deadline, because the government has 6 months to move, to either to approve or deny the claim. Now, they can deny it anytime. They can deny it the day after I file it. And then that starts a 6-month clock for me. Then I have 6 months from the date they deny it to file a case in federal court. And I'm trying to do it all at once so that I can, and my intention is to try to overwhelm the government with the volume of these cases, so that they are eventually left with the prospect of just, it's easier to pay these claims than to not. So did I answer your question well enough there, Mr.?
Yes, sir. But just one more thing. I don't want to waste your time. I kind of scanned this document, and one of the things it's talking about is loss of unemployment insurance coverage.
Sure.
How is this different from the unemployment benefits that some of us claimed and got paid when we got terminated?
So it may not be. So if they've already compensated you for some of this stuff, that would be their defense. So they would come back and say, well, we did pay Mr. Wendigo this back during the termination. But for the time that for the folks who were misclassified, and again, the form fills that you completed informed us whether or not you were making a claim, because some of you would have just had claims for unemployment, for lack of overtime minimum wage. But for many of you, you didn't get any benefits. You didn't get any workers' compensation, for example. That's one of the things that I'm picking on Jason, who's not here, but one of the things, he was injured on his job, and when he's working for the Department of Justice, and he didn't have a workers' compensation. He wasn't able to make a workers' compensation claim because they had him classified as a 1099, which is an illegal classification, which is where the state-based claim comes in. Because those state claims, like in Maryland, it's actually illegal to classify someone as a 1099 when they were a W-2. Now, for the folks who were moved over to PSCs, for example, at VOA, the government's argument there is, well, when we moved everybody to PSCs, we righted the ship, and we got everybody squared away. But the overwhelming evidence that I'm hearing back in these form fills and so forth is that nothing meaningful changed. There were still people who were required, for example, to be on call and not paid for their own call time. People were required to work overtime and then told they could get comp time. And the reason that comp time is not legal is because it doesn't actually pay you your time and a half. It just gives you time off at regular time rather than paying comp time, rather than paying time and a half. And again, I think there's a tougher hill to climb when it comes to whether or not, because you are W-2 when you're a PSC, but there's still for many PSCs, they worked as 1099s before they were converted to PSCs. Did that get there, Mr. Winston?
Yes, I was kind of comparing it to the DC unemployment benefits we claimed and got paid. And when it says loss of unemployment insurance coverage, I was wondering if
that would
that's
have been for the period of time before you were PSC. Like I said, if you were one of those people who worked as a 1099 before you were PSC, then you didn't get any unemployment insurance payments. And you didn't get, so the agency is required, when you're a regular W-2, the agency is required to pay into your unemployment insurance bucket while you're working. They're also required to pay the 7.65 employer match for your Social Security. They're supposed to pay for many state laws now have requirements to pay for benefits. If you have, in Colorado, it's every employee. For some states, it's every employee. If you have more than 10, the government clearly has more than 10 or 20 or whatever the number is. So there's lots of state requirements that the government wasn't paying attention to by virtue of the way they were employing you. And that's what we're focused on. And unemployment is one, workers' compensation is another. They weren't, for the whole time that you were 1099s, they weren't paying workers' comp on you guys, which was a huge exposure for you if you were injured.
all right. Thank you.
If they have a defense, if they want to say, well, here's money that Mr. Wendieman collected on unemployment while he was out, that's a defense for the actual unemployment period. But again, we have a separate retaliation claim going against the government for the fact that they fired you in May of 2025 anyway. So I'm trying to get future pay on that based on the fact that they retaliated against many of you and fired you.
So it doesn't matter if I already claimed unemployment.
You're not hurting anything.
Okay.
That'll be something the government says, hey, he gets that, whatever big number we were supposed to pay him gets reduced by this amount. That's all.
Thank you, sir.
Of course. I think, and Ignatius, Mr. Lamore, Ignatius, you were. And you're still muted if your time's up.
Joseph, I didn't raise my hand, sorry.
Yeah.
But I'm listening in.
Oh, did you mean to raise your hand?
No, I did
You
not.
know what? That might be I'm looking at my screen. That might be Miss Beasley. Miss Beasley, did you raise your hand?
I did.
Okay, you're right on my screen. You're right under Ignatius. So I apologize for the confusion. Go ahead.
Okay, so I just wanted to make 2 points or 1 point and one question. So you were in with SSA, that's who I work for, and that once people got on the Kamazi, they were paying the $5. That was going on even as individual contractors, but we were just with them.
Yep.
And so
I knew that was true. I didn't know it was universally true. I know that I know that there were some. I mean, I know there were some folks when they were 1090, on a BPA directly contracting with the government. They were pretty happy with that arrangement. But It wasn't, still wasn't legal.
No,
It still
no,
wasn't legal.
no. I'm about to say I don't know about being happy because, like you said, you could go there and
Yeah,
the judge could actually, the claimant could be there, the attorney could be there. Like you said, you've done this work, but
yeah,
maybe he asked you to get more evidence, so he
yeah.
didn't take any testimony. You still did not get paid,
That's right. And you were there, and you were
and
sitting,
we were all there.
and you were waiting, and Susie's about to. I've heard from Susie on it because she and I used to work in the same building sometimes. When I
Hmm.
was on the plaintiff side, when I was on the claimant side of things. So my origin story for the firm back in 2012 is when we were one trick pony. All we did was Social Security work. And
Right.
so we had, we'd go over there, and these folks. I mean, I was getting paid on what we won, but the court reporters could be in there for, if it was a judge down in Colorado Springs, it could be 45 minutes. If it was a judge in one of her first name was Robin, I remember her in Denver, she would have 2 and 3 hour long hearings.
I was just about to say that. Yeah, some people were very long-winded, so you could really be there till 5:30
Yeah,
and only had 2 hearings. You know
right.
what I mean? Essentially. So
Exactly. So
I just wanted to clear,
and this is,
make sure.
no, Miss Beasley, and I want you to hear me say this. The big, and I'm gonna put this in an email when I send this out today, and I'm gonna send this recording. But I want everyone on this call to hear me say, and everybody who gets this recording to hear me say this. That I want you to fact check me when we send these forms out, especially that sworn statement, because whatever makes it into the sworn statement should be what flows into the Form 95. All of it, what you put in the form, is what's supposed to flow into what I've trained the AI to flow into the sworn statement and into the Form 95. But having said that, when you look at the Form 95, line 12 of the line, or like 12D, is the quote unquote some certain. That some certain is required by statute. You have to put a number there, right?
Mhm.
If it's too high, don't worry about it, because if it's too high, the government's going to, we can negotiate that number down. If it's too low, I need to hear about it, because once we're locked into that number once we submit it to the government. Now, I put it, there's a qualifier in there that says that the claimant reserves the right to do A, B, and C. But even if we reserve that right, we have to go, if we find out, well, hey, the number was off by 100,000, and I found a claimant that we went through it, and that happened. I just have to file a new Form 95 with an updated some sort. That has to be in writing. So pay close attention. Everybody listening to everybody who's joined this call, everybody who is, everybody who gets this recording, and I'm going to include it in the email. Pay special attention to that line 12. Now, for the vast majority of, because I trained the AI about a third of the way through this, for the vast majority of you, there should be a follow-on after the line 12B. There's a follow-on A and section A and a follow-on section B. That section B, I believe, is the section, one of those two, and I'm not looking at it right now, unpacks for you and the government how we came to that number at 12.
Okay.
Right. So if you look, and it should say, like, for example, it'll say you work for 12 and a half years, 52 weeks a year times this
Yes.
amount of money overtime.
Mhm.
And this is the dollar amount. If there is a denominator that's wrong, right? If there's something like, hey, wait, this should be 13 years, not 12 years, or that's meaningful, you should let me know about that, right? If it's too low. If it's too high, again, we always have the authority to negotiate that down. And then if again, if a few of you have caught things that you weren't comfortable with in your sworn statement, again, I want you to think about in terms of materiality, right? Because that's the part we have to be careful about on a sworn statement. If it's, I worked 41 hours instead of 42 hours, that's not a material misstatement, right? We can always negotiate that down, and no one kept track. So it's really, you're just being, it's an informed, educated guess. But if it's, if it says I work for the Social Security Administration, it was really VOA, we need to change that, because I'm going to send these to the right. I need to send these to the right agency. So those are the kinds of things that, if it's material, if it really affects outcome, those are the things that I want to change. Because I said I've got 81 duplicates already, and I need to. If I spend we're at 200, let's call it 250, 280 folks right now. That number should eventually be will eventually land in the thousands. I don't know how many, but it'll end up in the thousands. We haven't even gotten the first shred of discovery from the government yet. So we're doing this right now with, by hook and by crook. So anyway, so just pay attention to that, but understand my big sense of urgency is getting as many of these claims into the agency by the end of this first week in June as I possibly can. And right now, so we've got 293 forms, 212 unique entries, and I'm trying, and I'm well. I was at last night when I went to bed. I was at like number 165. So I should be. I'm more than halfway there. I should be all the way there by the end of this week. All right, let me see whose hand.
Well, I have one more question.
Go ahead, Ms. Peace.
So the second thing I wanted to say, because I know that you talked about like statute of limitations with, some of our claims that they may try to,
Sure.
throw out or whatever. And you said something earlier about, like, for instance, with me, I started with the government in 2007, but then went to Kamazi in 2018. So I was one of the people who worked for that whole some of that year and didn't get paid for most of that time.
Sure.
Right. And so when we tried to go after Kamazi, because like you said, the government was saying it was Kamazi. Kamazi was saying it was the government, right? So when they say, oh, well, they ran out statute of limitation, well, we didn't even know who to go after because you guys was telling us it was one people, it was the contractor, and the contractor saying it's y'all. How were we supposed to know who to go after? So you're claiming something that we didn't even understand or even know how to rectify the situation.
So Ms. Beasley, you don't know this maybe, but you just articulated the defense against the statute of limitations, which is a term, you can write it down, Google it, look it up. It's called collateral estoppel, which means when a defendant basically tricks you into not filing a claim against them, then they are collaterally estopped from being able to rely on the statute of limitations. I've also argued, and I've argued this is currently at the Court of Appeals for the Federal Circuit under the FLSA claim. I have gone as far as to tell the government or argue that the government and the Court of Federal Claims argued that it was impossible to misclassify you because the government can't misclassify people because appointment was required. If the DOJ and the Court of Federal Claims and all these people are taking a position that it's not possible, and they're telling you that the VOA folks had contract provision that said you may not communicate that you are anything other than an independent contractor under fear of termination for default. I have argued 6 ways from Sunday that these contracts I expect I'll be arguing in the Court of Appeals for the Federal Circuit for this case again before the end of this calendar year, because the government's brief is due on my appeal on this issue by this week, I think, the 2nd or 3rd of June. And then I got a reply brief due before the end of June, and then it'll be fully briefed, and hopefully we end up on the court's calendar before the end of this year to argue another term here, equitable estoppel. That's one to write down in Google. The other one is the accrual suspension rule, which means that the statute of limitations cannot begin to run until you as a plaintiff knew or should have known about the cause of action in the first place. And if the government is actively telling you, it's not us, it's Kamazi, when they weren't paying Kamazi, I can tell you that with absolute authority.
Right, that's what I'm saying. When you said that, I was like,
a multi-million-dollar claim against the federal government for not paying Kamazi, and they ended up in bankruptcy because the government never paid them.
Right, because when we tried to go after them, that's what we were told. So essentially, Kamazi was right, because that's what they kept telling us, is that we're not being paid by them. Then if you ask the government, they were like, yeah, it's Kamazi's fault. You need to talk to them. Your contract is no longer with us. We can't talk to you about that.
They called it a privative contract. We have no privative contract with you, which, by the way, was why they created this contract in the first place. Because they didn't want to have these BPA contracts with you, where somebody probably
individuals.
Somebody woke up one day and said, "Oh, having 1,800 BPA contracts with VHRs is a bad idea because we're misclassifying everybody. You're walking in the same building with everybody else that are all W-2s around you, and you're doing a primary and essential role of the government. That's the term of art. Primary and essential role of the agency. You are doing court reportings for which the government was required by statute to do.
Mhm.
It's not like it was optional. They have to
Correct.
do those recordings. If they don't, it's an automatic, you know this already, it's an automatic remand for the claimant.
Yep.
All right. Now, let me see. Marie, I think you were next in the order. Oh, Erica's hand. Well, wait, I think I got Marie's hand was up first. Marie, go ahead. You're going to have to unmute Marie. Marie, you still, all right. I don't know if your hand went down. Ignatius, your hand is up this time. I'm not wrong on that. Go ahead.
You're no wrong at all, Joseph. Thank you very much. And also, I just want to thank you for raising the issue about fact checking to the team. And that brings me to the question that I wanted to ask. For those of us who had the duration that we worked at the various agencies decreased, are you able to then review the estimated amount being asked upwards? Because I'm guessing that the amount was proposed due to perhaps the number of years that we worked at the agency.
Let me repeat the question back. Is the question, hey, I worked for the agency for a period, like some of these folks at VOA went to work for, I had one I looked at over the week, last week, they started with like in 98. Like that's the farthest back so far. I thought Jason was the furthest back in like 2001 or 2002. Some of these folks went back to like 98. Is that the question? Like if you, I want to make sure I'm understanding the question, answering the question you're asking.
So my question is, for example, on my uh, standard form 95, I realized that instead of, say, I worked for the agency for 5 years, you had, say, 3 years. And so my question is, given the update and letting you know that, oh, instead of five, or no, instead of three, I did five, are you able to then review the
Yes,
amount
100%.
of money that you're asking upward?
Yeah, 100%. So what we want to do, like I said, and I have done this. I did this 2 weeks ago with an unrelated FTCA claim, a malpractice claim, where my client came to me. She'd already filed an FTCA claim, wrongful death, medical malpractice, and she'd only claimed $500,000. Well, her claim, when she came to me, I didn't know this, but it had actually already been rejected, but the government hadn't mailed the rejection yet. I refiled a new 95 and started the whole thing all over again. And I
Okay.
updated her claim in that instance to like, I don't know, $3 million or something like that. So, because her husband was a doctor and the VA killed him, and all that to say, yes. And I have, like I said, I have 81 duplicates from some of you guys. Some of those duplicates I think are a function of what you just explained. Hey, I missed something. I want to update this. I want to correct something. Certainly, you can do that. You don't have to fill a whole new form. Almost, I think all of you have gotten text messages from me through the system, through the Clio system. That's the 833 number. You can just respond to that. And hey, Joe, I missed something. It should, the Form 95, just like you said, Ignatius, the Form 95 says 3 years. It should have been 5 years. The what I did, so yours might have been early enough. I caught that error a while ago where it was limiting, because 3 years, the reason the AI was originally starting with 3 years is because 3 years is the statute of limitations on an FLSA claim. I went back and said, hey, don't ignore the statute of limitations because these folks didn't know about the claim, and it started doing it correctly. So if you've got a 95 that's limited to 3 and it should have been 5, 8, 10, whatever, let me know. Because again, we can always settle for less, but we can't ask for more after we, again, I want it so we can file. We haven't filed your 95, but when we file a 95, we can update it as long as we're in that 6 month window of when we originally filed. Does that make sense?
Thank you, Joe.
All right. Susie, your hand's been up. You've been patient.
Joe, I just wanted to add something about the BPA and the $5 charge.
Yes.
According to the BPA, if I remember correctly, and maybe Miss Beasley would remember as well, we were capped at $25 a day. So if you had 6 hearings scheduled, 7, 8, 9, we even had a judge that did 10 sometimes.
Is that Musk?
Could not earn more than $25 a day
For canceled hearings.
if the claimant didn't show up. And I can give you a specific date when I know I sat with Judge Fortune and nobody showed up all day.
Yeah. I remember Fortune. I remember one judge when I was doing this work in Connecticut. I don't want to war story you, but when I was doing this job in Connecticut, there was one judge on that had a habit one day a month. He would do what he called the rocket docket. He would bring in a series of
rocket docket.
Yep, they would bring in a series like 20 unrepresented claimants and just tell them, give them those
all at the same time, and then just whoever showed up.
Yeah, he would. Well, this judge would schedule them, but he would schedule them in 15-minute
increments. Judge Burkhardt in the Springs used to do that,
and then just give everybody the same spiel. You have a right to representation. Do you want to go out and get that representation? Here's a list of Social Security attorneys. See you later. And I expect those VHRs were getting paid the minimum for being there, because none of those hearings took any testimony. Well, yes, I would like to go. Yes, I would like to go get an attorney. But listen, here's another thing. Why you guys are at it. So you guys also. So I'm talking a lot of this conversation today. I want it to be. It's intentionally about logistics, because you're gonna. We're gonna get to an overwhelming number eventually. For me as an individual, I've got 2 law firms working on this. The folks down in Texas, I'm having to educate them on this. They're very smart employment lawyers. They have sued the federal government 0 times. So I'm having to educate them on the suing the federal government side. They're very smart on employment. They've had big cases like against Domino's and national cases, right? But I'm having to educate them on the government side, and they don't have anything. They have no idea how to do 95s. So you have all the other thing. We've talked about Clio. We've talked about text messaging and updating stuff there. And I love that platform, because I literally can just get Susie's text, click a link, I'm in her case, click another link, I'm in her form, and I can update the form and then send it back out. And that's one of the things. You guys have all met Carolee, at least virtually. She's probably out on a walk right now or back. She and I are working as a team to get these things out for you to sign. The other thing you've seen from her is a collab space link, and you've seen a Clio portal link. That is for ease of, if you've got that old BP. No, the reason I don't want to stress you guys too hard on like finding the old BPA contract is because that stuff is all. If you have it, great. You probably saved me, some time. But literally every bit of that stuff is publicly available information. I can either get it on sam.gov, or I think the Social Security Administration used to compete those through another portal. They didn't use SAM or what was FedBizOps back then, but it's all publicly available data. If you've got it, I expect that every one of those BPA contracts are going to read the same, because they would release these things like they would do like 12 or 1,300 BPAs a year. And a BPA, by the way, is just, for all of you who care about government contracting, it's a blanket purchase agreement. It commits the government to nothing. It just gives the government the ability to pay you. And it's a terrible contract. It's the case law hates BPAs. But again, they don't get to use a BPA to sidestep the employment protection laws that are there for your protection. So that's why we're doing these cases. So again, if you have anything that needs a correction or an update, the most urgent thing I'm trying to do now is to get the clock started. Once we get the clock started, we can update the amounts, we can update the forms. I can do it with a very simple form fill and go from there. But if any of you guys have your hands on an old contract, just drop it in the portal. Any one of the portals will do, and we'll get it included into your vault. All right. Susie, does that help at all?
Yeah, I just wanted you to know that we were capped on $25 a day.
That is extraordinary stuff. Yeah. The $5 a pop is terrible, but $25 a day is like that's pouring salt on the wound. Erica, your hand is up. I want to answer your question.
Good morning.
Good morning.
I'm just listening to all this 1099. It almost sounds like something out of The Good Wife. The scenes where they would just bring everyone in and you're assigned to somebody. But I'm not an attorney. So based on everything, do I belong in this case?
Well, Erica, did you and I speak yesterday when I was on my way to that meeting?
Yes, sir. Yes, we did.
I'm gonna schedule a separate meeting with you, and we're gonna go over. And again, I don't want to talk about your case in front of everybody else, but I do want to talk to you specifically about your case, I do think you have a meritorious claim, but we have to have a separate conversation.
My FLSA is already filed
right.
under Michael V. Via.
Yeah. So we won't talk about the other things, but I'll talk to you. I'm going to send you a calendar link for you to get on my calendar this week. Okay.
I would greatly appreciate that, and good luck, everybody.
Thank you. All right, guys, we are at 10:56. We've covered a lot of materials, but I want to reemphasize that we're at the logistics side of this thing, right? We got to get this form completed, mailed to the government, get the clock started. Then we can continue, as we lawyers like to say, we can continue to paper it, right? We can continue to paper the file over time, collect documents. There's so many of you that what one of you is likely missing, or what one of you may be missing, another of you likely has. Because the government was so, and it's kind of good for me as to being on this side of the case. The government was so belligerent in its behavior because it believed it was operating with impunity. So it just treated everyone the same. Again, they had all of these, like I was shocked. I read this probably 3 years ago, where they just amended the contract with the VOA people and said, you've got to be on call 24/7. And I'm like, what? That's ridiculous. Nobody is ever on call. Doctors in emergency rooms are not on call 24/7. That's absurd that somebody would be on call. And the way it read was like, you have to be ready at a moment's notice. It didn't give them like a time, like you have to be able to respond in an hour. Once upon a time, no one on this call will care. But once upon a time, when I was a much younger man and a much lighter man, I was a ranger in Savannah, an Army Ranger. And for 3 months out of the year, well, it was like 2 months at a time, and we were on a 3-unit rotation. We would be on RF1, Ranger Ready, RRF1. So we had to be on Ranger Ready Force 1. So we had to be ready to go in 18 hours, wheels up. Even then, we all had beepers. You guys might remember beepers. We had beepers, and we had to be in the property within 2 hours of when they sent out a Bravo notification. So we had to be in. The Social Security folks didn't even have that. They were just like, you have to be on call and be, or not Social Security, the VOA people. You have to be on call at the drop of a hat because there's some political unrest in another country, and you have to be able to show up and do that. Nazanin, am I doing that right? Nazanin?
Yes. After all this talk, I'm sorry, last minute, I remembered something I thought that I should mention. And when we became PSCs at Voice of America, we had a reward system like preview. They gave us review, not preview. I'm sorry, review and we had 4 levels, level 1, 2, 3, 4. 4 was excellent, 1 was poor, and 2 and 3 doing their job or being exceptional.
Sure.
And the first couple of years, I got good ratings. So the bonus was based on ratings. So if you have 3 or 4, you get bonus. So 2 years, I got a rating 3 and 4. And then after that, I got 2 and 2. Doing the same thing, not on top of that, I had more responsibilities,
Sure.
but the rating changed. When a few of us complained about the ratings, they said, oh, we don't have budget for bonuses, so we don't give, anybody's getting 2 because we don't have budget for bonuses. Even though we are doing exceptional jobs, we didn't get bonus because they said we don't have fund for it, and that's why they rate us 2. That also affects if we wanted to get promotion or get hired. If they looked back at those ratings, they say, oh, she's just doing her job. She's not doing anything exceptional.
Sure.
And then that was another thing that happened for most of us, especially these past couple of years, we didn't get any bonuses.
So that would fall still under a state-based claim. It just becomes a breach of contract. So because they pretextually failed to promote, failed to, they basically, and the evidence of that you just articulated. If they gave everybody a 2, right, and nobody's a 3 or 4 because they didn't have the money to give out bonuses. I mean, bonuses are generally discretionary, right? But they should have amended the contract if they weren't going to give people the bonuses, and they had, or renegotiate the contract. But that's one of the other things that I was really unhappy about, the way the relationship that you all as PSCs had with the federal government. Because the way they did this, it didn't even allow you to really collectively bargain. It didn't even allow you to unionize and be able to do the things that almost any other employer would have been able to do. But Nazanin, what I'd ask you to do is, if you've got a connection with the portal I know of, I've texted you before, and my wife has, just take that story you just told me and just put it in a text or in the client portal, and I'll incorporate it in the claims. But again, we've tried to build enough cushion into the claims where if there's like a breach of contract claim like you're talking about, we can include that in the sum certain. All right.
Okay, great. Thank you so much.
I second.
Sorry. You were going to say you second that?
Yeah, I'll second that, because that's what happened to most of us, I believe.
Well, that's a pattern and practice claim. That's called a pattern and practice claim. So when they're doing it to everybody, that's a pattern and practice claim.
Yeah, when they have money, they will rate you good. When they don't, they don't.
So
for doing the same thing. Thank you. I hope
they put the bonuses in writing at all?
No, they just rate you. But when you go, behind the scene and ask why, they say they don't have the money. Like
the question I had that I want to hear from you: did they contractually obligate themselves to the bonus in writing? Did they say in writing, if you get a 3 or 4, you get a bonus? Or was it just?
I have to look at the details.
I'm curious if they said it if they said it in a group-wide meeting, it still forms a contract. But I just need to know whether we're going to have to collect that. We can get it in sworn statements. I got plenty of you guys, and I have an apparatus now where I feel very comfortable. If we need to get more sworn statements, I can send out another form fill for you guys. You guys have been really, I try not to bombard you with form fills, but if I'm learning that that this is out there, then I can convert these PDFs into sworn statements very quickly, as you've seen.
Yeah, but definitely it's a practice over there.
Thank you.
And
Mohammed, you had a question.
I'm sorry to interrupt you. I think we have in our Paycom system the ratings. I can get screenshots of each year for comparison to see how from exceptional I went down to just doing my job.
Sure, acceptable. You went from exceptional to acceptable, right?
Yes. Thank you. All right. Thank you.
Perfect. Mohammed, how are you doing?
Can you hear?
Yes, I can. Go ahead. What's going
on? One of the questions I want to ask you, actually, I know you're not a tax expert, but in this filing, it says that personal injury. And do we have to pay taxes on any reward?
So here's the thing. I'm not a tax expert, but I am going to be, none of you know this, and you would have, I'll be sitting for my CFP in July. And CFP is a certified financial planner. And I'll be sitting for that. I'm licensed, and again, you guys would have no reason to know about this or care about this, but I'm a licensed investment advisor, Series 6, Series 63, Series 65. I'll be sitting for my certified financial planner in July, hopefully, knock on wood. I'll pass that, but I can answer that question. So for under personal injury, anything that the court rules is personal injury, right? It is not taxable as ordinary income. Anything that the court or usually that's negotiated. If it's lost wages, then that is taxed as ordinary income, which is why, by the way, we're going for 2x, right? Because and attorney's fees, because the goal is to leave you with at least as much money as you would have gotten had the government not broken the rules, right? You're not better off if you get what you were going to get 5 years ago and you have to pay taxes on that, right? So we want to make sure that you're at least as well off. So that's why we have the liquidated damages. So if the government shorted you 100,000, you get 200,000 plus you get attorney's fees. And remember, we're also suing for the 7.65% on the self-employment tax for the people who were 1099 when they should have been W-2. So that is how we get to now. Again, there's a morass in here. There's a few folks that worked for VOA and Social Security, like Carmazzi and Techniarts and all these other folks who were the original employer misclassified, and they'll say, well, that's because, like Jason's another example. Jason has to be a 1099. The law does not care. The law doesn't care if you ask to be a 1099. If somebody comes into my office tomorrow and they said they want to be a paralegal, work for me, and they want to be paid as a 1099, the only answer I'm allowed to give them is no. No, you cannot be a 1099. You have to be a W-2 employee because the law requires it. And more importantly, the IRS requires it. Because what ends up happening is the employer intentionally avoids paying their 7.65% by misclassifying it. They also don't pay the workers' compensation, which leaves the worker exposed. I mean, you could slip and fall in your parking lot on the way, and you could be doing a very non-dangerous job, like a film editor for VOA or a VHR for Social Security. But if you slip and fall going down the stairs, that's a workers' compensation claim. And if you're not getting workers' comp, and you're having to pay for your own health benefits and pay for your own deductible, that's not legal. So this is all the stuff that we're trying to capture. I don't know if that answered your question or not, Mohammed. I was trying to answer.
Yes, it's pretty clear. Thank you. Appreciate it.
All right, guys. I sometimes get on my own little soapbox, and I don't mean to bore you with all of that, but I want to thank you guys for one, for showing up, two, for continuing to jump through all of the hoops I have to ask you guys to jump through so we can get this case moving. I've seen some renewed excitement. I think the reason for that is that this Form 95 actually has like an actual dollar amount in it, which helps people. It takes this case from the abstract where we're just talking about we might get something to, oh wait, you mean there might be 200,000, 300,000, 100, $1 million. Some of those claims for folks who've gone back to the beginning of time have like $1 million claims because the government did. Now, I don't know. I can't sit here and promise you that that's going to be the original. That's going to be the ultimate outcome. It's a lot of it's going to be because we're charting some uncharted territory. We're creating some new case law where no one has, as Captain Kirk would say, no man has gone before. But we've already created some case law, and I don't mind creating some more. We're at 11:07. I want to give you guys your Sunday back. Are there any other questions that that are burning a hole in your head and you want to get answered now? If you guys have a question that's related to your individual case, continue to use the text in the Clio portal and stuff like that, because then we can get those questions answered for you in real time. If that is it, I'll let you guys go. And again, you should see you in. Let me see. I've got some more. I've got some Q&A. It's not. Oh, Marie, I did let you unmute. Let me see here. All right. Let me see. Say text me directly. All right. Daryl, contractor review in the past, you bring that up if you work on the contracts. All right, so the form link, Daryl, I'll send you another form link. All right. All right, guys, I will see you guys on the next meeting.
All right, thanks.
Take care now.
Thank you, Joseph.
Take care now.